If you are a federal employee or if you know someone who is, this video is a must watch because the Department of Energy recently announced mass layoffs and we've heard the news about more cuts to come. But the question is, are they following the law as they are conducting these layoffs? And that's what we are talking about today. By the end of this video, you will understand how federal workers are protected from wrongful termination, what the Department of Energy and additional government layoffs mean for employees and their legal rights, and why public sector workers, government workers, have stronger job protections than private or non government employees, and what steps you can take if your termination wasn't handled correctly. And stay with me until the end because this could be the difference between losing your job unfairly and knowing how to fight back. Hi, I'm Harlow Reed, employment lawyer, HR consultant, and creator of the HR Insider. On this channel, I do more than share my legal opinion. I break down real legal cases to show how the law might apply to your situation. So, just like you, I have heard a lot of the chatter and buzz online about government employees being fired or laid off, and definitely sensing the panic and absolute chaos that's being caused by the process that's being used when terminating employees. Terminations are such a sensitive process, and it is it affects people's lives in such significant ways that we really have to be careful about how it's done. And it was just really important for me to get online and share my thoughts about what is happening because if there is one Supreme Court case that changes everything for government employees, and I mean everything in terms of their job protections and security, it's Cleveland Board of Education versus Loudermill because this was the landmark case that was ruled on by the Supreme Court that established the right of government workers to due process before termination. Before termination, even after termination, there are steps that must be followed, and it could be the key to challenging wrongful layoffs that are happening right now. So let's talk about it. The content shared on this channel is for informational purposes only and shouldn't be taken as legal advice. Always consult a qualified attorney or HR professional for guidance on your specific situation. And hey, don't forget to like and subscribe. This case starts with a man named James Louderman, who was a security guard for the Cleveland Board of Education. James was hired in 1975, and on his job application, he stated that he had never been convicted of a felony. But 11 months after he was hired, and as a part of just a routine assessment of his employment records, the Cleveland Board of Education discovered that he had, in fact, been convicted of grand larceny in 1968. The Cleveland Board of Education issued a letter to James on November 3rd, 1980, and that letter notified him that he was being terminated because of his dishonesty in filling out his employment application. James was not given the opportunity to respond to the charge of dishonesty or to challenge his termination. And on November 13th, 1980, the board officially approved the termination, and James was never given an opportunity to address the issue. Now, under Ohio law, James was classified as a civil servant, and civil servant employees can be terminated only for cause and are also given the right to an administrative review of their termination. So, due to these rights that James Louderman was entitled to receive as a result of his classification as a civil servant, he decided to file an appeal with the Cleveland Civil Service Commission. He did that on November 12th, 1980, and in January of 1981, a hearing was held, and Louderman was allowed to argue his position about why he shouldn't have been terminated. And he said that he thought his 1968 larceny conviction was a misdemeanor rather than a felony. And so the Cleveland Civil Service Commission decided that even if that was Louderman's position, they would go ahead and uphold the decision of the Cleveland Board of Education to terminate his employment. Louderman's attorneys then filed a lawsuit. In their lawsuit, they said that the decision to terminate him was unconstitutional because it didn't give him an opportunity to respond to the charges against him prior to his termination. The lawsuit also argued that Louderman's termination was unconstitutional because he was denied his legally required post termination process, which gives him additional protections that are owed to government workers. So the Supreme Court will sometimes combine similar cases together so that they can address bigger constitutional issues all at one time. And that's exactly what happened in this case. The Supreme Court combined Louderman's case with another case involving also a government employee named Richard Donnelly. And Richard was a bus mechanic for the Parma Board of Education. Richard was a long term employee, but in August of 1977, he was terminated because he failed an eye exam. He was offered a chance to retake the examination, but he did not. So instead of retaking the eye exam, just like James Louderman, Richard Donnelly appealed his termination to the Civil Service Commission, who ordered that Richard be reinstated but without back pay. Following the decision by the Civil Service Commission, Richard Donnelly filed his own lawsuit, arguing that his termination was unconstitutional for the same reasons that James Louderman gave. Both lawsuits made their way to the Supreme Court, where they were combined, and in a 5-4 decision, the United States Supreme Court ruled that public employees must be given due process before termination. Now, for the important part of this entire case, why did the court decide the way it did, and what does the decision mean for government workers today? Both of the employees in this case were classified as civil servants who could be terminated only for cause, and both were entitled to post termination administrative review for decisions regarding their employment status. But in this case, neither employee was given the opportunity to respond to the charges made against them prior to their termination. Civil servants, federal employees, and other public sector workers, government workers, they have greater employment protections than private sector employees or non government workers due to constitutional safeguards, rights, and procedural requirements that have to be applied to employees who work in government positions. Government employees have special protections under the Constitution, and one of these special protections is called due process. And so, what this means is if you work in the government, whether that's the federal, state, or local government, you actually have something called a property interest in your job. And basically, that means that your job has certain protections under the Constitution. This is going to be covered under the 14th Amendment for those state and local workers, and under the 5th Amendment if you are a federal employee. And this means that your job isn't just something you can easily lose without your employer following the right process. So, what does it mean for you if you are a government employee? Well, if your employer wants to fire you, they can't just say, hey, pack up your desk, you're done. They have to give you a formal notice explaining why they are considering firing you. They have to give you an explanation of the evidence that they have. So they can't just say, we don't like you, we don't want you here anymore, and call it a day. They have to give you a chance to respond. What that means is you get to tell your side of the story before the final decision is made. And this all comes from the Supreme Court case we are talking about today, Cleveland Board of Education versus Loudermill. This ruling in this case made it crystal clear that public employees, government employees, have due process rights that they must receive before termination. Now, if you are a private sector or non government employee, you don't get these rights. You don't get this level of privilege. And that's because the Constitution protects against government actions, not what private employers do. If you work at a private company, you can be fired on the spot unless your termination breaks a law like discrimination or retaliation. In addition to their protections under the Constitution, federal workers also have stronger appeal rights. So let's say if you get fired as a federal worker and you're just out of luck, nope, you are not. You actually have a much better shot at fighting back compared to someone in the private sector. And that's because federal employees can appeal their termination to something called the Merit Systems Protection Board, or MSPB, which basically looks at the case and decides if the termination was actually fair. If there was any wrongdoing, they can reinstate you. And if you believe you were fired for discrimination, you can go to the EEOC or take what's called a mixed case to federal court. Now, private sector employees, those who don't work for the government, they don't get this kind of automatic appeal process. If you're fired and you think it was illegal and you work in the private sector, your only option is to sue. And that can be a very long, emotionally draining, and expensive process. And all of this simply means that if you are a federal employee, you are not an at will employee like a non government employee or a private employee. You can't just be fired for no reason or any reason at all. And in most cases, your employer actually has to show just cause, which means they have to prove why your termination is legitimate before they do it. And if you work for a state or local government, you probably have civil service protections as well, which are laws that say you can only be fired for specific reasons. But if you are a private sector employee, someone who works for a corporation, someone who is not a government employee, you are almost always at will. And this means that your boss can fire you for pretty much any reason or no reason at all. The only exception is if you have an employment contract or your termination violates a federal law like discrimination or retaliation or some other state or local jurisdiction law. Other than that, there's no guarantee at all that you'll keep your job. So, if you are someone who's working for the federal government or a public agency, you have more rights than private employees when it comes to terminations, when it comes to appeals. And that doesn't mean that you can't be fired. It doesn't mean that. But it does mean that your employer has to follow the law and give you due process. If you are a government employee who's facing termination, make sure that you receive the notice, proper notice that you are entitled to under the law. Make sure that you get an explanation, that you have an opportunity to respond. And if that termination does occur, make sure that you appeal it, that you follow your appeals process that would be outlined within the government or public employer that you report to. And if these things don't happen, you may have a legal case and should consult with an attorney who specializes in employment law. So what do you think about this case? Have you or someone you know faced a similar situation? Do you have someone that is currently working in the federal government and believes that their termination is pending? Talk about it in the comments. And if you found this video helpful, like, share, and subscribe for more insights on employment rights and HR policies. If you have a topic you want me to cover, drop it in the comments. Happy to do that. Stay tuned for my next video where I'll discuss another major employment law case. See you then.